1970 expanded the size of the faculty from 1 to 2. Outside of a brief stint as a member of the United States Congress, Professor Tucker continued at the law school until his death in 1897, and he served as the dean of the law school for his last 4 years on the faculty. The Tucker Lecture Series began in 1949 and has featured a number of prominent academics, jurists, and public figures. In keeping with that line of distinguished speakers, it is my privilege to welcome today Chief Judge Diane Wood of the United States Court of Appeals for the 7th Circuit. Chief Judge Wood's remarkable biographical information is included in your pamphlet, but let me note a few aspects of her background. Chief Judge Wood received a Bachelor of Arts from the University of Texas, graduating with the highest honors. She received her Juris Doctor from the University of Texas School of Law, where she was elected in the Order of the Coit. Following law school, she clerked for Judge Irving L. Goldberg of the United States Court of Appeals for the 5th Circuit. The following year, she clerked for United States Supreme Court Justice Harry A. Blackmun. After that clerkship, she spent a brief period at the Office of the Legal Advisor in the State Department, and then Chief Judge Wood began her career as a legal academic at the Georgetown University Law Center. Shortly thereafter, she joined the faculty of the University of Chicago Law School, served as a full-time professor until her appointment to the federal bench in 1995, and she still serves as a senior lecturer at that law school. In 1990, Chief Judge Wood was named the Harold J. and Marion F. Green Professor in International Legal Studies at Chicago Law School, becoming the first woman to hold a chaired professorship at that school. From 1993 until her appointment to the 7th Circuit, Chief Judge Wood served as the Deputy Assistant Attorney General in the Antitrust Division of the Justice Department. Chief Judge Wood is a Fellow of the American Academy of Arts and Sciences, and she is a member of the Council of the American Law Institute. In short, she seems to have done it all. It's a pleasure to have Chief Judge Wood with us here today to speak on the quiet crisis in access to justice. Before we give a warm welcome to Chief Justice Wood, I'll mention that after her comments, she's open to take questions related to the content of her talk today and anything else that students or members of the audience might like to ask. So please join me in giving a warm welcome to Chief Judge Wood.
Many thanks for that kind introduction, Dean Hellwig. It's a real honor to be here to present the Tucker Lecture. It obviously has a long and distinguished history, so I'm very pleased to be able to play my part in that. I chose the topic of access to justice because it's something that I've been spending a lot of time working on lately, and the longer I remain on the bench, the more pressing I realize this problem is. And sad to say, it's not really a new problem. In 1919, a person named Reginald Heber Smith published a book, Justice and the Poor, and the book created great stir in the legal profession. Smith, who incidentally, and you may come to curse his name for this reason, apparently introduced the billable hour, as you're wondering, do I really have enough? And also the associated 6-minute increment to the billable hour. So he did all of that, but in this book, Justice and the Poor, he argued as follows, and this is a quote. He said, "The administration of American justice is not impartial. The rich and the poor do not stand on an equality before the law. The traditional method of providing justice has operated to close the doors of the courts to the poor and has caused a gross denial of justice in all parts of the country to millions of persons." He went on to say this was of grave concern because equal access to justice is, as he put it, a basic principle on which our entire plan of justice is built. Without it, he said, there can be no justice at all. I think we would probably all agree with that today. Though we don't ordinarily think of the Roaring '20s as a period of great altruism, The legal profession, to its credit, did respond swiftly to Smith's rebuke. The American Bar Association established a standing committee on legal aid and indigent defendants, and the book, Smith's book, remained instrumental, galvanizing support for legal aid efforts over the next several decades. Nearly a century later, the Legal Services Corporation took a look at the situation a couple of years ago, actually, a very thorough look. And they compiled some similarly sobering statistics about our current state of affairs. A daunting number of Americans, they thought something on the order of 63.4 million people, 1 in 5, are eligible for LSC-funded assistance, yet only a fraction of people actually receive the help that they need. Budget cuts in recent years have led to the elimination of nearly 1,500 positions from LSC-funded programs, and those programs are thus now forced to turn away a great number, certainly over half, of the people who come to them seeking aid. And who, you might ask, is eligible for LSC assistance? Some of you may know this, but recall that they're precluded by their organic law from doing anything on the criminal side, so that's out. Indigent criminal defendants are, of course, entitled to appointed counsel. You know this under Gideon versus Wainwright. But defender services around the country are stretched notoriously thin. In fact, about 2 weeks ago, I was in Cambridge, and I was talking with the Vice President of the Legal Services Corporation, Dean Martha Minow of the Harvard Law School, and the statistics that she has collected suggest that the average number of felony cases that a public defender is carrying on his or her docket at this point approaches 1,600. Now that's an insane number. It gives you maybe time enough to say, "Hi, I'm Susie Smith, I'm going to be your lawyer, let's plead." And that's really not something worthy of being called much legal assistance. And as far as the other side of the LSC, on the civil side, they can, of course, do civil assistance, nothing for illegal immigrants, no class actions, but other, that to one side, civil matters. Now, these are problems. This lack of legal assistance on both sides of the ledger are problems that touch all of us. They affect the safety and stability of our families and our communities. They affect the reliability of housing markets. They affect the protection of consumers from unscrupulous actors in the commercial arena. And they affect the overall health of our communities, which is strengthened when people receive the assistance to which they are entitled by law. Now, many of the areas of this undermet need that I'm talking about are issues addressed principally by state law. It's family law, it's landlord-tenant law, it's contract law, it's domestic violence protections, and most of the criminal law matters, for that matter, are matters of state law. So you may ask, what does a federal judge have to say about that? And as I'll tell you, I mean, it certainly affects us as well, but as a judge, as a concerned citizen, and as a member of the bar, I am quite concerned, and I'd like to give you a little bit of my own perspective. So at the risk of overwhelming or boring or whatever you with statistics, let me give you some basic background information about what's going on in the federal courts. The Administrative Office of the U.S. Courts, which is the administrative arm that helps us keep running, maintains statistics, actually rather detailed statistics, about a huge variety of topics that concern the courts. Among those statistics are some about the number of pro se cases, that is to say, people with no lawyer, that are coming through the doors. Let's not worry about Ferretta cases. Remember, in the criminal law, if a person really doesn't want to have a lawyer, under the Supreme Court's decision in Ferretta, they don't have to have a lawyer. Those people are generally not smart to do this, but it happens. They're a special case. They do anyway have a legal entitlement to counsel. But on the civil side, over 295,000 civil cases were filed in the federal courts during the 12-month period ending September 30, 2014. And those are the statistics I'll be using. I won't repeat that. Of that number, a little more than a quarter, 27.5%, were pro se. And if you look at the difference between prisoner petitions and non-prisoner cases, prisoner cases, non-prisoner cases, it turns out that of the 60,000, almost 61,000 prisoner cases filed over that time, 93.5% are pro se. And on the non-prisoner side, it's about 10% are pro se. I looked just to see how representative the Northern District of Illinois is, which is the district where Chicago is located, and that's where we sit. And in the Northern District of Illinois, just a shade less than a quarter of the civil cases filed by people are filed by people who are unrepresented, pro se cases. And the prisoners, again, file pro se almost all the time. These data are a little bit harder to come by for the courts of appeals, but not impossible. Information from the administrative office tells us that 28,000 and some appeals are pro se as of the time of filing, and the number gets slightly larger as of the time of termination. That's because sometimes there's a disagreement between client and the lawyer withdraws, or for whatever reason there's a change. Most of those pro se cases are civil, although there are some that are not. At the Seventh Circuit, we had 3,000 pro se cases at filing in the past year. Now, it's possible for somebody who's filed a pro se case to get a court-appointed or a court-recruited lawyer. At the district court level in the Northern District of Illinois, I'm told by the clerk, that in 2014 they recruited counsel in almost 500 cases, 489 cases out of about 12,000 cases. So, if you're a glass half empty person, maybe that means a lot of cases didn't get a lawyer, but the judges are a little bit reluctant to press a lawyer into voluntary service when there's no guarantee of any compensation for that lawyer's efforts, because we all understand that there's a business side of the legal profession, and one needs to be careful about that. Our court addressed in an en-banc decision the guidelines for the district courts to use in deciding whether to recruit a volunteer lawyer in a case a couple of years back, about 7 years ago, called Pruitt against Moat. And we noted that although there's no constitutional or statutory right to court-appointed counsel in federal civil litigation, an indigent civil litigant may ask the district court to request an attorney to represent him pro bono. And so we established a two-part standard for that. We said the court must first ask whether the indigent person has made a reasonable effort to find counsel for him or herself. If so, secondly, the court should consider two things. One, how hard is the case? And that actually has a practical aspect as well as a legal aspect. If you've got a prisoner in a high-security prison and the prisoner needs expert testimony about environmental conditions or expert medical testimony, they can't go out and find an expert as easily as you could. So that's a type of difficulty. So the court is supposed to consider, let's just say, all of the difficulties in pursuing the case, and also is supposed to consider the plaintiff's competence, and if the plaintiff appears able to handle the case without legal assistance. So looking at all of that, the district court judge will make a global decision about whether to recruit counsel for that person. And as I say, there's a pretty careful assessment that's made. So counsel are not just recruited promiscuously, although the number does seem to be going up somewhat. This leaves lots of people unrepresented, and the district courts are working to address the unique problems these litigants experience. If you go to the website of almost any district court, certainly the Northern District of Illinois, one of the first things you see is a link for the pro se litigant. Now, my only problem with that is my concern that the set of people who need this kind of legal assistance, I think, probably corresponds pretty well to the set of people who don't have a computer at home, who don't have a Wi-Fi network, and who might not even know enough how to use it if they go to a public library or something. So bear that in mind as we go on. But at least it's a start. It's there for somebody. There's a link for the pro se litigant. The court maintains resources for people who file a civil case without an attorney. They do caution, as they must, under bar rules, that they say, the rules, procedures, and law that affect your case are very often hard to understand. With that in mind, you should seriously consider trying to obtain professional legal assistance from an attorney instead of representing yourself as a pro se party. That's a quote. But realistically, there are people who simply don't have the money. There are thousands of people in the Northern District of Illinois alone who just cannot afford to pay a lawyer. And many of them have no idea where to turn for free and competent, competent legal help. The staff of the clerk's office will try to help them by answering procedural questions. A committee that I established for the Seventh Circuit maybe about a year and a half ago, has developed forms for pro se people who are bringing employment discrimination actions and who are bringing complaints about prison conditions. Can use these forms, and we may see how well they work and whether we should develop more. But there's only so far we can go. Obviously, the people in the clerk's office can't give legal advice, and that's a significant limitation. So, again, remembering that's a little bit of the picture of the federal courts. The state courts have much more of the problem. Maybe the federal courts overall do something on the order of 10% of the legal business in the United States. The other 90% happens in the state courts. And it happens in lots of places. It happens in administrative agencies. Somebody wants welfare benefits, somebody wants veterans benefits, somebody needs medical assistance. It happens in encounters with social workers. It happens in all sorts of state court proceedings, small claims courts, and out-of-court situations. So there are many, many people who need legal services who are not getting them. So what are we going to do? I think clearly we need to do something. And again, I'm going to remind you that this seems to be a perennial topic. Back in 1964, here's what somebody said. The problems of the poor are not new problems. There's been long and devoted service to the legal problems of the poor by legal aid societies and public defenders in many cities. But without disrespect to this important work, we cannot translate our new concern into successful action simply by providing more of the same. There must be new techniques, new services, and new forms of interprofessional cooperation to match our new interests. That was former Attorney General Nicholas Katzenbach. And, here we are today. I'm telling you, it has not changed that much. One thing that has changed, though, and I think for the better, is the role of pro bono lawyering in helping to meet these needs. American lawyers have always provided services to the poor, but it's been much more ad hoc and individualized. Over the past 25 years or so, this type of assistance has become more streamlined and more organized. There have been organizational structures coming across professional associations, law firms, state-sponsored legal services programs, nonprofit public interest groups. There are a lot of reasons for this, including the dramatic cuts to the federal legal services funding during the 80s and 90s and the LSC restrictions that I mentioned. But what I'm suggesting to you is that the reality today is that the institutionalized pro bono program has become the dominant method of delivering free legal services to poor people in America. And if we're going to be serious about addressing these legal services, we need to think about what resources are available, what do they have, what might we add to those resources. If we don't, we risk leaving millions of people behind. So let me suggest a few possibilities. One thing that seems absolutely essential to me is the need at the lawyer level to have more troops on the ground, more people involved in this. or people to whom indigent clients can turn for help. You've seen a lot of proposals, I suspect. In some states and in some places, people have discussed various forms of mandatory pro bono obligations for members of the bar as one way of expanding the number of lawyers who would be available to meet that need. I am not going to take a position on whether this ought to be mandatory, but it does seem to me that it can certainly be encouraged even more firmly. And it also seems to me that there are many options beyond just simply shaking your finger at somebody and saying you should provide pro bono services. To begin with, look at you. We have untapped resources, starting with law students. Most law schools do have clinical education in their programs now, and many of those clinical programs are exactly serving the people who can't otherwise afford legal services. Many students are taking advantage of that option. I'm sure that's true here. So a great many clinics are serving needy people, and that's great as far as it goes. On the other hand, it's not clear to me how much this can be expanded, because of course this is the baseline. This is the baseline against which we have millions of people not served. It's not clear to me that the law schools have the resources to expand the number of clinics very significantly beyond that which they are doing right now. It's expensive to run a clinic. Faculty-student ratios need to be small, supervision needs to be there, and I don't probably need to tell you that law school tuition probably is about high enough. I'm staggered when I think of it. Two of my children are lawyers, and I was staggered when they went to law school, and that was a couple of years ago. So there's only so much we can do in terms of expansion of resources, looking at law schools and looking at the law school clinics, even though they're doing great work and we couldn't do without it. I suppose it would be possible to think of expanding academy-bar relationships so that each student devotes the equivalent of a course to some kind of service to some kind of needy person. The service could be many things. At the University of Chicago, we have everything from clinics on criminal law to clinics on people with mental disabilities to an entrepreneurship clinic that helps people in underserved neighborhoods incorporate new businesses and find their way through the network of regulations that the capitalist world requires. And it's a great clinic. It does a lot of things. There are lots of ways you can serve. So some kind of course like that. Now, I recognize that wouldn't do a whole lot for the people who don't live in the cities and towns where the 200 ABA accredited law schools are located, but on the other hand, it would certainly reach a lot of people. So that would be one way in which we could take advantage of people at the younger end of the profession. At the other end of the age spectrum, well, actually, let me say one more word about the younger end. As you will know, since the great financial crises of 2008, 2009, there were some years where the overhang of recent law graduates on the market and the mismatch between the number of jobs available and those recent graduates was pretty striking. My son graduated from law school in 2009, and he did have a job, and nobody called him up and said, we were just kidding, you don't have a job anymore. But that happened to some people he knew. And there were other people who wound up having their jobs deferred for a year and all sorts of things. And you think, this market just isn't working. Here are all these highly trained, smart, recent law school graduates. Here are all these people who need legal assistance, and we can't figure out how to match them up. And we should figure out a way how to match them up. Now, one way that has struck me is one could look at the other end of the age spectrum, at the retired or the semi-retired lawyers, people who are euphemistically called emeritus lawyers in the LSC's report of the pro bono task force, which I'm going to talk about in a minute. But there are a lot of highly skilled lawyers who don't want to be working at full bore anymore. Well, I don't see why you couldn't find some way to assure them, that their license is going to stay good if they do the pro bono services. Maybe each one of them agrees to supervise 3 or 4 of these recent law graduates so that you get some training and you get some quality control. And maybe that's a way of unleashing these resources for these people who really need the help. There could well be other ways. There certainly are other groups who have tapped into the resource of the senior lawyers. So, for instance, the American Bar Association, in the years immediately following the breakup of the Soviet Union and the return to democracy of the East European countries, established its Central and East European Law Initiative, called CELI by everybody, and used senior lawyers for the most part for this. They found lawyers who were willing to travel to a Central European country for a 6-month stint or a 12-month stint, so that they weren't just parachuting in, telling somebody what to do with their life and leaving, but really embedding themselves in the culture of the country. And it seems to me if you can find lawyers who are going to do that, I don't see why you can't find lawyers who would be willing to keep their bar membership active, volunteer, 10 hours a week. You need to work out some details. And I've actually talked to state Supreme Court justices about this. I think this can be done. And it's not just the young lawyers and the older lawyers, the emeritus lawyers, we need to be thinking about. We should make it easier for lawyers at small firms, solo practitioners, lawyers in rural areas to plug into pro bono opportunities. Just to take one group, there are over 100,000 lawyers who work for the federal government. Many thousands more work in state and local governments. So we should consider how to make it possible for them to participate. It isn't all that easy right now, by the way. There is, for example, for federal judicial employees, a code of conduct for judicial employees. And that code of conduct prohibits my law clerks, for instance, from representing clients through a legal aid organization in Chicago, even if the help does not involve litigation, even if the help would not ever in any way come before a federal court. And that level of strictness may not be necessary. Another group, and I think this is really starting to change in a very positive direction, are the many lawyers who work in general counsel's offices of companies. They, too, are members of the bar, and there have been some very fine examples of that kind of support for pro bono work. Another way that we can make it easier for lawyers is to break down the job a little bit. What do I mean by that? Suppose somebody comes to you and says, well, here's this prisoner, he's complaining about the medical care he received in the prison. A case like the one my son is doing, where there's a prisoner in Illinois who has cystic fibrosis, and for reasons best known to itself, the Illinois prison people decided to put him in a cell with a smoking cellmate. If you don't know about cystic fibrosis, it's a very bad thing to do to somebody with that condition. So he's put in endless hours over the years on this case. But suppose you're just brought in to formulate the complaint, actually write it in English, which is not, whatever language they're writing in, sometimes it's not English, maybe individual English words that are discernible, but they're just kind of handwriting these things. I've seen more than I care to say. So drafting a complaint, maybe that's all you have to do. Maybe, and the district courts in Illinois are doing this to some degree, they say to a lawyer, we want you to come in for purposes of settlement discussions, but you're not going to be now kind of committing your own resources and those of your firms for the next 5 years on a blank check basis. But you can help with settlement discussions. So there might be ways of breaking down the tasks in a case that makes a lawyer in today's difficult world more comfortable taking on the responsibility. So again, there are going to be many other ideas of how we can make better use and more comprehensive use of lawyers, and we need to think about all of them. That said, let me move to my second point. Even if we did everything that you could imagine with lawyers, there is still going to be a tremendous amount of unmet need. There just aren't, we wouldn't even want enough lawyers to meet all of this, actually, for somebody who sold a lot of lawyers in our country. So we need to be smarter about how we can use non-lawyers. Now, this is delicate territory, especially in the eyes of many of the state bars, but it really is time, and long since time, to talk about this seriously. We have to think about how to expand who is able to give the services and who is authorized to give the services. In my view, we can take some lessons from the health professions. For every doctor, there are several people who they sometimes like to call physician extenders. This could be a nurse midwife who works with an obstetrician. It could be a physical therapist who works with an orthopedic or neurological specialist. It could be an LPN who's going to give you a flu shot if you go to your local drugstore. The medical profession uses these people all over the place. The legal profession has been far less enthusiastic about throwing the doors open to non-lawyers who work directly with clients, even if done under the supervision of a lawyer. And I will say, briefly, as a former antitrust lawyer, cartels rarely want to be broken up, but sometimes that's just the way it is. We need to take a fresh look at this, and it's my feeling anyhow that the cat may already be out of the bag. And what do I mean by that? Information presented to the American Bar Association's Commission on Ethics 2020, which did its work a couple of years ago, reveals that the market has left the organized bar in the dust. There are internet sites galore that offer do-it-yourself legal kits for everything from incorporation to divorce to bankruptcies to wills. Now, those of us inside the guild may bemoan, and may with very good reason bemoan, this development because the quality of these things varies hugely, and there is a serious risk that people may be harmed more than helped. But nonetheless, I would be astounded if those sites are not here to stay. So the obvious answer is, rather than wring our hands and try to stamp them out, we take a lesson from King Canute and recognize that we cannot stop the tide. There may be ways to turn these sites to positive uses if we can figure out effective ways to link them up with qualified counsel and some sort of supervision. So that's one set of problems. Non-lawyers, who can be of some assistance to pro se litigants, are another type of solution. This has existed in the prisons for years, and actually many of the prison legal assistants become excellent with experience. I sometimes think some of their briefs are better than counsel's briefs, and I'm really quite serious about that. The organized bar doesn't have much to say about it. I think it's been a rather ostrich-like approach. The ABA's model rules address a lawyer's responsibilities for non-lawyer assistance, that's Rule 5.3, but they don't have much to say about the possible ways in which legal assistants or lawyer extenders might enable one lawyer to help a greater number of people. You could imagine a trained person whose primary job was triage, just as you see when you go to the emergency room. It's not a doctor who's sitting there doing the triage, it's a nurse. Send the people with serious legal problems off to the lawyer's office. Send the people who really just need an educated advocate to make a few telephone calls. You know, say to the landlord, you know what, they really want their deposit back. You know, you don't have to be a lawyer to say that. You just have to be somebody who's not going to be buffaloed by the landlord being grumpy on the other end of the phone. Or maybe you just need help. Maybe you need somebody to explain a complicated document to the legal to the person in question. Obviously, these assistants would need training and supervision, but I don't think that's out of reach. In fact, some law schools are starting to think about one-year programs that might actually produce some kind of certificate for a legal assistant. You could imagine a public benefits legal assistant. You could imagine an immigration legal assistant. You could imagine a legal assistant in domestic relations or domestic violence, and so on. A consumer affairs legal assistant. And with a one-year program that was affordable, and then being able to get out there and work under the supervision of a lawyer, all of a sudden you have more people able to reach the people who need legal help. Washington State is taking some interesting steps in this direction. They have a new limited, I don't know how they came up with this name, limited licensed legal technician. They're carried away with the L's, but it's a program adopted by the Washington Supreme Court in 2012. It allows non-lawyers to train for 3,000 hours, gain a license in a specific field, and practice limited forms of law. So let me see. So these LLLTs can help people with specific legal problems with minimal supervision. Right now, the program is geared toward family law, including domestic violence and child custody, but it obviously could expand to other areas. So a former law clerk of mine, Rebecca Oney, did something similar to this for kind of a blend of law and medicine. She actually started a company when she was a student at Harvard College about 18 years ago, and the company, whose website you can still find because it's thriving, is called Health Leads. Now, Rebecca has been showered with awards for the innovative approach Health Leads takes to delivering health care to low-income people. Just to name a few, she was named to the... Actually, my son thought it was very cool when I hired her as a law clerk because she'd been on the front page of Rolling Stone at that point. But that was then, this is now. She was named to the 2010 Power List that O magazine compiles each year of 20 women who are changing the world for the better. She got a Harvard Genius Grant in 2009 for her work in the company. She received the John F. Kennedy New Frontier Award. So this company is just amazing. So what they do, they have some 22 clinics, and their physicians can, quote, prescribe, food, housing, health insurance, job training, fuel assistance, other resources, just as they do for medication. So they're thinking more broadly. And, critically, they locate these help desks in as many places as they can find, in pediatric outpatient places, adolescent, prenatal clinics, health department clinics, federal qualified health centers. And they reach thousands and thousands of families each year. They use carefully trained college student volunteers who help connect the patients with this widely defined array of resources that they need. And these volunteers, in turn, work with clinic physicians, social workers, and lawyers to ensure that the services are properly integrated. So why couldn't we do something like that for legal services? I think the services needed by our indigent potential clients also run the gamut. You could put desks in a wide variety of community locations. You could put them in Social Security offices, public libraries, as they are in fact doing in the state of Hawaii, I'm told. Elementary schools, health clinics, the local Walmart, whatever. You could get out there where the people are, is the point. You don't expect them to have a laptop, and you don't expect them to travel some punitive distance when they don't maybe even have a car, to get to the courthouse. So I think this could be done, and you could have trained volunteers who would know whether this was a case that you had to refer to the lawyer in charge, or whether this was a case where perhaps a simpler solution is available. This is a little bit of what happened in New York City after 9/11. The New York City Bar really stepped up and had an amazing response to that, all on a pro bono basis. In the aftermath of the attack, of course, there were people who were trying to arrange funerals, burials, apply for aid, administer estates, and on and on. And the City Bar convened lawyers from the legal service organizations, the private bar, in-house counsel, the courts, law schools, and they worked on a facilitator project to train volunteer lawyers and others to assist with these things. So it was really a very fine set of responses, and it helped a huge number of people. So lastly, let's just think for a second about how we measure success. Law firms do that quite well. Obviously, they know how many hours they devoted to each client, what pro bono matters were handled, and the like. But as I say, I think wonderful as their services are, we could not survive without them. We are so fortunate to have the help of the law firms that respond enthusiastically when we reach out and ask for help. But we need more. This toxic combination of huge numbers of people who need legal services and strained public budgets is not, in my estimation, going away anytime soon. So, given this enormous burden that the pro bono lawyers are shouldering, we need to come up with more and better solutions. So these topics are addressed in large part in this October 2012 final report of the Pro Bono Task Force that the Legal Services Corporation issued. I served for a little while in that task force's Big Ideas Committee, and they did come up with a number of interesting recommendations. No one in the LSC task force thinks that that report was the end of the line. The hope was that it would spark debate and then action all over the country, and that it would begin to make equal justice for all a reality, not just a phrase etched in a marble building somewhere far away. So thank you. Questions, comments about either that or anything else that I may happen to know anything about? Yes, ma'am.
I'm intrigued by that last thing you talked about, but how is that different? It sounds like a huge expansion of current paralegal programs, and also who pays these people?
Right. It's as I see it, it's different from the paralegal programs in that the paralegals right now are inside the law firms, right? They're working. I mean, actually both of my kids worked as paralegals for a while. I'm pretty familiar with what that looks like, you know. And they're the legal assistant types, and then they're the professional paralegals who go and they get a degree and they make a career out of it. So I'm seeing this as more of an expansion. You know, if you need physical therapy, you can go to a physical therapy clinic, and the physical therapists are there, and they're running the clinic, and they're doing with you what they need. I'm sure, you know, they have relationships with doctors, but it's a more direct form of giving the services. And I guess I should say, I think, although there's certainly many people in this number that I was talking about to get to your second point, who might not be able to pay as much as a dime, there are a lot of people who can pay something, but who are shocked at the idea that they would be paying somebody even $100 an hour. I mean, that... For many people, that's a lot of money. You know, in 2 hours, $200. So something that would allow a lower cost basis might also help reach people who, you know, who technically are just below the median income in the United States, but who just don't think they can afford legal services at the present price structure. Yeah.
Going back to your earlier point about your suggestion on kind of fragmenting, I guess, or piecemealing legal services, for example, saying the lawyer should come in for settlement negotiations and help out with that, do you foresee maybe a conflict or kind of a creation of miscommunication or inconsistency in that you might be involving multiple lawyers or specialists within a particular case, and that might negatively affect, say, you know, an otherwise pro se defendant, in that you might have 5 or 6 different lawyers doing different work? How would you maybe, do you have an idea of how you would get around that or prevent that from diminishing the quality of legal assistance?
No, it's a very good point. I think what you have to do is be very careful to make sure that you discover the areas that will properly segment. So with the settlement programs, which are in existence, and they seem to work fine, you know, you get the client to say, you know, this lawyer is going to come in and see if he can come up with a settlement or she can come up with a settlement for your case. Obviously, the client can approve or disapprove the settlement at the end. It's not like the lawyer's going to force it on them. But working with the other side, it's a lot more effective. And so settlement does seem to be something that segments pretty naturally. And actually, in a lot of courts, the district judge who would hear the case is not going to be the one handling the settlement conference anyway. It's going to be a magistrate judge, so that the district judge doesn't get, inappropriately involved in what amount of money is really going to do it for you. So people like that separation. Drafting a complaint is another thing that seems to segment. I don't know how you could segment in the middle of discovery. There's too many strategic decisions are being made. And I'm not even sure about trial, because it'd be very frustrating to be the trial lawyer without having had control of the discovery process. But there are some areas that do seem to segment. Yes, ma'am.
Going back to your people not wanting to pay $100 an hour, do you think it's circular when someone goes through a graduate program, law school, med school, where they come out with an amount of debt and expect to make a bare minimum of X many hundreds of dollars an hour? Do you think that is a part of the underlying problem, or if we're going to base a solution off of the medical field, if we could alleviate some of the problems that we're seeing in that field as well?
Well, certainly the cost of getting either a medical or a legal education are immense. I mean, they certainly are for the medical side as well. And the economic structure that the legal profession has been built on, as you know, is under attack. The idea of the billable hour is under attack, as probably should be. On the other hand, I will tell you, you want to be careful not to let the pendulum swing too far. I'll give you again a personal example here. In the medical profession, the basic rule is procedures pay. And so you bill on the basis of procedures. There are all these codes that they put in. It was this procedure, it was that procedure. My husband happens to be on the medical faculty at Northwestern, and his specialty, he's a neurologist. His specialty is peripheral nervous disorders, and in particular, Lou Gehrig's disease, ALS. And ALS isn't a procedure. He sits down when he's trying to tell somebody, I'm really sorry to tell you, but you have a fatal disease and you're probably going to be dead in 3 years. You don't tell people that in 5 minutes. That would be inhuman. So he'll sit down with the family. He'll take an hour if that's what it takes. He'll take an hour and a half. Make sure all the questions are answered. He gets paid $0 for that hour or hour and a half. Whereas, he really, it strikes me as a lawyer would think of that as compensable time. But the billing model in the medical profession doesn't think of it as compensable time. If he does a muscle biopsy, fine. That gets reimbursed. So you don't want to miss the value of the time completely in whatever replacement model you decide to use. But the expectation of compensation for lawyers in big cities has probably followed the cost of the education. The partners think they're going to get all this money, and I assure you, my children make more money than I do. Not even close, actually. It's hard to say. They're going to big firms. Maybe I'll come out and stick up my hat, next Christmas or something. But you're right. I mean, you need to think of the model. You need to think of the expense of the education. People, of course, for lawyers have talked about, is the third year of law school really worth it? Should there be some kind of apprenticeship program, or should we look more like Canada, where there's still 3 years of law school, but then the first year or the second year out are at a much lower compensation level, recognizing that you're still learning, and maybe that will make the clients happier. Those are all worthwhile things to do. I don't know if they're going to directly answer my problem. Yes, sir.
Your idea about pairing law students with emeritus lawyers, I'm curious about how you envision that working in practice. Do you see that as being something organized by law schools to supplement existing clinics at a lower cost?
Well, I was talking, again, to some state Supreme Court justices about this. There are a couple of problems that you would want to solve. One problem is just physically, where is it going to be? Is there going to be enough income to support having a standalone office somewhere, or perhaps might the law, if the lawyer is still of counsel of the law firm, where he or she was. Would the law firm be willing to devote a certain amount of space to that? Seems to me that might be a pretty easy way to do things. So anyway, physical location is one problem. A second problem is malpractice insurance, because the lawyers on both sides, the junior lawyers and the emeritus lawyers, are not going to be immune from the need for some kind of malpractice insurance. Third problem is licensure. Now, maybe the emeritus lawyer wouldn't otherwise have kept up the license. So that's pretty easy for the state Supreme Courts to solve. They can just say, if you've reached a certain point and you're doing this, then we're going to charge you zero, for your license this coming year, assuming obviously there's no ethical blot on your record. And they also could relieve you of CLE requirements, for example, continuing legal education requirements, which exist in most states. So you need to do something about licensure to make sure that that was in place. I don't know. I mean, those I think are the three big ones that come to my mind. But I can't believe, though they're very concrete problems, it seems to me they must be capable of a solution. And and actually this is one of the first things I thought about as the number of younger people looking for positions was such a big factor in the legal market for those years. And by the way, I think it's getting better, but it was a big issue for a while. And it just seemed like such a shame that people couldn't somehow link up better with others who needed the service. Yes?
I'm curious about those pay per month legal services plans. I don't think you mentioned it, but
The HMO type plan, yeah.
Right, where you pay like $20 and you have access to a huge legal network. Do you know if there's been any, research as to how effective that's been in expanding access to, like everyday people?
The unions tended to use that, I think, more than just the general market, if I'm remembering correctly. Sometimes it would be in a collective bargaining agreement or a feature of union membership. And I think it has not caught on more broadly, probably for some of the same reasons that it's a less popular model at this point in the the medical profession. The HMO model still exists, but the PPO model, the preferred provider model, is one that people are just much more comfortable with, because even if the list is not 100% of the providers, the notion that if you don't like provider A, you can go to provider B and maybe just have a better communication with them. That would apply to lawyers as well, for sure. So some kind of capitation, though, is not impossible. I think the problem is quality control of who's in the network. Yeah.
You talked a lot about the inability of just the availability of lawyers for the very poor. But what about the difference between the quality of lawyers that are available to the very poor and to the very rich? Is there a way to lessen that gap?
Well, I wish there were. I mean, I'll tell you where I see it. Well, I mean, I see it all the time in a lot of places. But one of the places that I feel very badly whenever I see it, and it happens a lot, is in immigration cases. As you may know, after the Board of Immigration Appeals is finished with a case, in all but a vanishingly small number of cases, one takes a direct appeal to the Federal Court of Appeals for the area covered by where the immigration court sat. So there are no district courts involved, and we see great numbers of cases where people are filing, they're actually called petitions for review. They're filing petitions for review for everything from denial of asylum to denial of adjustment of status to whatever. And there are people in the immigration bar who should be disbarred for incompetence. They're just awful. You know, they start by telling the Board of Immigration Appeals that they're going to file an appellate brief from the immigration judge's decision to the BIA, and they never bother to file a brief. They just don't file one. They don't even file a bad brief. They don't file one. And so there's an exhaustion of remedies requirement. If the BIA was never asked to look at an issue, and then the person files a petition for review with the Court of Appeals, the government comes right in and says, well, they didn't exhaust that issue before the BIA, they lose. And the government's right. That's what the law says. So you have to deny the petition for review because this stupid lawyer didn't file the brief that the lawyer promised to file. Or the lawyer will say, oh, you know, we need to gather some more information for this asylum petition to show that, you know, the guy really was beat up in the streets of Dar es Salaam. And they don't file anything, you know, or they file, you know, one, 20 years out of date, piece of paper saying it's a dangerous place or something. And, it's just awful. So we see that. And of course, those clients all lose, and they're powerless. You can say, oh, you can file a malpractice action against so-and-so. No, they can't. They've been removed from the country, and they don't have any money anyway, and they probably don't speak English. And that is a meaningless remedy in that situation. Other end of the spectrum, there are law schools with fantastic immigration clinics who represent some people. There are law firms that I can think of around the country, New York, Chicago, Los Angeles, San Francisco, who, as part of their pro bono efforts, take a certain number of these cases. Those people get relief. Isn't that interesting? Having a good lawyer makes a big difference, and it makes me crazy. I mean, it's something that really falls on the bar to regulate its members better, but the bar doesn't really regulate them for competence. The bar does regulate them for, commingling client funds or having inappropriate sexual relations with your client or something like that. Fine, you should regulate all of that. But competence, not so much. Once you've taken the bar exam, you're just kind of out there. And I don't really know, though I wish I did know, of these scolding lawyers. In fact, I've been sponsoring, we had a rash of lawyers that we thought were not very good in the Seventh Circuit, and there had been some opinions that some of my colleagues had written that were quite critical of these lawyers. So I announced at the circuit conference this past year in May that rather than just criticizing after the fact, we were going to try to help people get better. So we've been having 3 appellate practice seminars at an extremely modest cost. I think it's either $50 or $100. 50 if you're below a certain age, 100 otherwise. We had one in Indianapolis. We had one last month in Chicago. We have one coming up in Milwaukee, where we have all the members of our court. We've got them streaming so that we can explain, how should you write a good brief? What needs to be in it? What does the clerk's office do? What do all these other people do? And think, well, maybe we'll reach some people who need the help and we want to give it. We rather have good briefs up front than criticizing them at the back end. So I don't know. Maybe that was what the hope of the CLE requirements was, but I'm not sure that it's done as much as it could have. Yes.
Chief Judge Wood, thank you so much for raising immigration. I'm the director of the Immigrant Rights Clinic here.
Well,
it's very near to my heart. Thank you for the vote of confidence, by the way.
I'm not kidding, by the way. I know where the good places are.
You may be aware in the immigration context there is a model similar to your proposal, the BIA accredited representatives. We have a couple here in the Shenandoah Valley. They try and extend immigration services in those communities that they couldn't pay for before. And the model works okay, but those people never go to court. They don't do some of the more complex work. You, I'm sure, also know that Chief Judge Katzmann from the Second Circuit supported the Immigrant Justice Corps with a mixture of public and private money providing pro bono, if you will, public defenders for immigrants in removal proceedings. And there's a hope that that spreads to other jurisdictions. I'm curious if there's any interest in Chicago.
Yes, there definitely is interest in Chicago. I'm quite familiar with that. I'm very good friends with Bob Katzmann, and it's a very good program. Obviously, in the Second Circuit, they were just drowning in immigration cases for a while. Maybe not quite as bad anymore, but But yes, I mean, all of those ideas, and actually I think, I'm glad you mentioned that, because there are other areas too where the idea of having non-lawyer representatives, non-lawyer assistants of some type has been tried on a subject matter by subject matter basis, even in patent law. I mean, there are people that you can do that who are not necessarily lawyers. So tax, I think, is another. You have accountants helping you. So I'm glad to see all of that. I mean, I think what I'm trying to push for is more experimentation on that line, and certainly Judge Katzman's idea is something that the immigrant bar is looking at carefully in Chicago.
I don't mean to foreclose any questions. Are there any more? Yeah. Oh, okay. Well, let me just wrap up the lecture by extending my thanks, all of our thanks, to Chief Judge Wood for a wonderful Tucker lecture. Real quick, I do want to put in a plug for our law school. You mentioned as one solution to this pervasive problem, the ability of law school clinics to serve the underrepresented, and we heard from Professor Balaarte, who does lead up our immigration rights clinic. We actually have 6 live client clinics here at the law school, all of which serve a strong public service angle. But you're right that you can only do so much with those clinics in terms when the primary focus is to educate students in the case. There's only so many people you can serve, but we'd like to think that we're doing our part here. One more comment before we finish. It is remarkable that, or it's interesting to think that right now opportunities in the legal profession appear significantly constrained to what they might have appeared a decade ago. Even on the other hand, there is this vast group of people who are not being served. And so you can look out into the future and see this remarkable space of opportunity for new law school graduates. And it'll be interesting to see what the next generation of lawyers does. If we don't do anything, then groups like LegalZoom and those, what do they call legal self-help, right? They're going to end up occupying the space. It'll just be interesting to see what the next generation can do to actually improve the legal profession's service to society. So with that, I do have one gift, a small gift I'd like to give to Chief Judge Wood, just to remind you of your time here. But let's all give her a warm
here or for your Until last year, I wasn't crying at my wife's, but we got married last year, so I was like,
yeah, I had one year out of work. Here, so we had to do a married father.
that's when we went to
The advantage of practice is that you always know which side you're on. You don't cheat. You know exactly which side you're on, and you should prepare contingency. You're thinking it's a jury. Jury, right? Yeah. Like you were doing that.
all those classes I took were 12 years ago. So I don't remember.
You know what? They don't count a lot of what was the credit constitution? They don't count. Once you get that,
We're excited. So proud of you.
the problem.
Top of the class.
And I've graduated.
They're all like, how do you research 13 circuits? You can do
Have you had your
many of them have.
Yeah, good to see you. We'll take care of it. Okay. All right. So you expect me to move on?
Okay.
Okay. am not the reason you're happy. I make a pretty small
Okay.
At this point, yeah, that would definitely perfection. Yeah, but my capture.
And I just want to bring everybody
I'll go with you. Actually, I gotta run upstairs and then we go. Cool? So we'll say remove the front end.
Oh, great. Okay. Yeah. What about the yeah, so obviously.
Congratulations. Thank you. That was great. Fantastic. I loved your closing remarks.
Make sure it's still there.
I'm happy.
Exactly.
I was part of my class.
This was great.
Yeah, I was just saying, you haven't read it.
Yeah, he talked about the Magna Carta. Yeah.
I mean, I know Rousseau.
I feel like that was so good. Yeah, it was great. Yeah, yours usually it's in the fall. Yeah, it was really good talk. Yeah,
the other Mark's.
Well,
He would be so what were you going to have?
We had plenty of fun.
Yes.
Yeah. Yes. This is part of it.
I wanted to get another part more about taxes. On behalf of the client. I also have tax documents well over 3 years. So it goes back to her. Slice out that portion they do that. Get his calendar call where the pool of tax dollars shows up. They basically find it I'm not your it's like they're being reasonable, settle, or yeah, the data are
Okay, grow up. It's different than the typical law school. Really
Yes, exactly. Yeah, hey, put it there, and we made it happen.
Good. I'm looking forward to it.
That also used to be able to schedule, I guess their schedule was so tight, it was probably set up by your predecessor also.
Well, actually, what's
That's
happened
correct.
is we
That's the big
didn't,
opportunity.
it wasn't on the law school calendar. So
I
normally.
mean, that's something the students don't.
Yeah, that would have been.
And it just wasn't on the calendar.
Really good experience. Yeah, it's more.
You asked a great question.
You can actually
Yeah.
spend more time.
Yeah.
You jumped in there, right? Like, Brad,
We do it very quickly,
But challenging.
Yeah.
Yeah.
you know,
Yeah,
The one thing is parking out.
The message of the CLA.
Yeah.
So I click on and like, let them know you're still watching.
Yeah, we're just talking about the ceiling.
Yes.
Are you
So
still
it's
there?
like,
Are you still there?
Congress was too long.
and I'm
about
sure-
doing it. What if they just, okay, well, they just pass a law every like 20 years. It's a court package.
It's a combination, yeah, it's a combination
That's
of
interesting. It's a whole idea.
years of experience plus years of oversight.
Can you give that historical
Means
loss?
that the historical loss becomes legal.
Yeah, you were like, what about applicants?
Right.
It's just like.
Right.
I agree with him, though, it would sacrifice, any such notion would sacrifice.
Okay.
I just think they were already.
Well,
Well,
we want us for Bono to get 2 more so that we can.
So that's.
Right here.
You know,
Yeah.
video solid on as you can.
Yeah.
To have like 40 or 50.
Have that. There's a lot of things to it.
Right? That's me. That's highly politicized.
Well, you know, last year,
Essentially, I mean, you're opening for stuff for somebody
amendment,
else.
of course, he thinks it
Bill,
ought
so
to
you can
be,
get more
you
reinforcement.
serve 18 years, and it rotates so that every 2 years you've got one going off and another coming on.
Interesting.
So, yeah.
Very interesting.
We spend all of its time.
The flip side of what you just mentioned might be something like Proverbs, which is where the conservatives put him there. Thinking
First year
he's going to be this ultra conservative. Well, he is. Well, he has such a high which I think is interesting. So I think you can't, I mean, there's some problems with swing, but they thought would be conservative.
So, I mean, it's very close. Like, I'm immediately going to see here.
Kennedy is a swing, he's mostly conservative.
Right. So that's the advantage of the permit fees. You know your stuff.
Yeah.
If you're political,
Well, that is true.
but try like you.
I mean, particularly the
We ought to have Trump in Congress, though.
I would expect any nomination.
Oh, it's maybe like a 10-time senator from the state.
Highly unlikely to go anywhere, and I think even
That's
consensus.
some terms in Congress that like
Oh, yeah.
Nobody.
There's plenty of time.
I was thinking it was never passed.
Well, it wasn't necessarily federal, law, but
Definitely
I
get
think
more
the
free.
state tried to do
Congress,
that.
what, do they have any?
And to say, I don't think.
That's right.
I'm
No.
not sure.
Every state, states do get more.
Well, they talked about it. That doesn't need to be
That's interesting. That's a conflict of interest. Who would then pass that law? I mean, there's some interest. Right?
Well, it was a part when it was on the
It was, but the
contract with them, not contract on there. Contract with them.
One might as well.
Right. Exactly.
Yeah, and she was great. Great talker.
Yes.
Great
Almost everything.
Yeah, I think it was a quarter.
I mean, I know, yeah. It's just
Oh, right.
Yeah.
Right. I know that.
Yeah, I say sometimes I think I want,
Yeah, that's true. I think it would be hard.
everything's
On a very large scale. It does.
Right.
That's
That's right.
I was going to ask about what about the idea of returning.
Might be in line.
Yeah.
Yeah, every day.
But that's one way.
Well, a lot of members do that.
I know. So certainly it can be done. We used to do it here, obviously.
Yeah, it was originally.
But now, you would look at the ADA requirements. So most of you have 3.
She does.
Yeah.
No, it's not.
Well, if anyone could pioneer, you think of it now.
Yeah.
If any school could be the first so long. So uniquely
You'd
positioned
be
because of
3
the structure of
undergrads,
the
he was
schools.
law school.
Yeah.
apprenticeship. That's right. Wonderful, wonderful, wonderful. Thank you all for helping us there.
Well, I'm glad to hear that things are going well. Yeah, I'd definitely happy to come over to the space. Interested in having me, so. Just, yeah, shoot me another referral back there.
I'll see you.
Yeah, I think, it'd be nice to invite. Excuse me. The more than anything, that can be a key central administration.